You've been in a crash and you're hurting, and now the insurance adjuster's calling, sounding friendly, asking questions like they're on your side. But here's what you probably don't realize: every word you say on the call can be twisted and used against you. I'm Guy DiMartino. I'm a personal injury lawyer here in Indiana, and I've seen hundreds of clients get lowballed because they didn't know what to say when they received the phone call. That's why in this video, I'll show you the 5 questions adjusters hope you never ask, because when you do, the whole game changes. So you stay in control of your claim, protect your rights from day one, and stop the adjuster from walking all over you. Let's get right into the first question. How did you calculate the value of my claim? Insurance adjusters in Indiana don't want you to ask this because it puts them on the spot. You're essentially asking them to show you their math. Adjusters often present their offer like it's set in stone, hoping you'll take it at face value. But here's the real secret. There's no magic formula. There's no single computer number for a broken leg or concussion or weeks of missed work. Instead, adjusters use a mix of software, guidelines, and their own judgment. Here's what they hope you don't realize. Their first offer is rarely their best offer. They usually start low, betting you're feeling overwhelmed or in a hurry to settle your claim. If you ask how they came up with the number, you force them to explain themselves. If they can't break down their reasoning, it's a sign their process is more about saving money for the company than truly helping you recover. Let me share a quick story. I work with a client from Chicago who had a serious back injury after an Indiana car accident. The insurance company offered her $8,000, claiming it was based on her medical bills and inconvenience. When we asked for the detail, what bills they included, how they valued her pain, how about her lost wages, suddenly their tune changed. The final offer became a starting point for real negotiations, and we settled for more than triple the original amount the adjuster was offering the client. In Indiana, you have the right to know exactly how an adjuster is valuing your claim. Don't settle for a vague answer. Ask for a breakdown. What bills did they include? And additionally, you want to ask, are they accounting for future treatment? What about pain and suffering? If they can't or won't show you how they reached their number, that's a red flag and a great reason to push back or get your own lawyer involved. This is a question insurance adjusters never want to answer. What damages are you leaving out? Either on purpose or not, adjusters often forget certain types of damages when they make an offer. They focus on the most obvious, the ER visit, maybe a few days of lost work, but in Indiana, you're entitled to more than just that. The law says you can recover all your harms and losses caused by the accident, not just the ones that are easy to add up. Let's break down the basics. There are 2 main types of damages: economic damages and non-economic damages. Economic damages are tangible damages. They are your bills, ambulance rides, hospital stays, physical therapy, medication, and lost paychecks. Non-economic damages are trickier, but just as real. Pain, stress, anxiety, and the way that the accident and injury has changed your life. Say you broke your arm in a slip and fall at a Valparaiso grocery store. The insurance company might offer to cover your ER bill, but what about the weeks you couldn't cook, drive, or even hug your kids? What about the hobbies you missed out on, or the sleep you lost worrying about recovery? These are all damages under Indiana law. I've seen adjusters leave out things like ongoing therapy, prescription costs, mileage, to medical appointments, and even household help you needed. In one case, a client wasn't offered anything for the anxiety attacks that he started having after the accident. Once we brought it up to the insurance adjuster, it added thousands to his settlement. If you suspect they're ignoring certain damages, ask them directly. What about my ongoing pain? What about my future treatments? Are you considering how this injury has impacted my daily life? If you hear silence, hesitation, or a quick subject change, that's a cue to dig deeper with the adjuster. Now let's talk about evidence. Here's the third question to put to the adjuster and put them on the defensive. What evidence are you using or ignoring in my case? This is so important. Insurance companies aren't on your side. They're looking for reasons to reduce your claim. And that means picking and choosing the evidence that works best for them, not for you. They might forget to mention key facts, downplay your symptoms, or outright ignore medical reports that don't fit their narrative. Think about a motorcycle crash in Fort Wayne. Maybe the police report says you weren't at fault, but the adjuster keeps bringing up a witness who thought you were speeding. Or maybe your doctor wrote that you'll need treatment for another year, but the adjuster only counted the bills that you wrapped up to date. That's not fair play, and it's not what Indiana law expects. You have the right to know what evidence is being used to decide your claim. Also ask, are you considering my most recent doctor's reports? Did you review all the photos from the scene? What about my physical therapy notes or the statement from my spouse about how this has changed my life or our family's life? If something's missing, call it out. In one case, a client of mine in Cherville suffered from a post-concussion symptoms well after her medical bills stopped piling up. The insurance company ignored her neurologist's diagnosis and tried to end the offer there. When we pressed for what evidence they'd left out, we found that they hadn't read her full file. Once everything was on the table, her settlement was more than twice the original amount. Always ask for a complete list of the records and reports and statements that the adjuster is using when valuing your claim. If they brush you off or refuse to share that information, that's a clear sign they aren't playing fair. Don't be afraid to insist or to call an Indiana personal injury lawyer who can demand the transparency that you deserve. Here's a question that flips the pressure back on the adjuster. What if I don't accept this offer right now? Insurance companies love urgency. They want you to think their offer is the only one you'll ever get, and that if you don't grab it immediately, you'll lose everything. But in Indiana, that's just not true. You have time. The law gives you up to 2 years from the date of the accident to file a lawsuit for most injury claims. That's called the statute of limitations. Unless your case is right up against that deadline, there's no reason to rush. I've seen adjusters say things like, "This is our final offer," or "We'll have to close your file if you don't sign today." It's a scare tactic. The truth is, adjusters sometimes get bonuses for settling claims quickly and cheaply. They hope you'll panic, skip your research, and sign away your rights. If you ask, "What happens if I wait?" you'll see some interesting reactions. Sometimes they'll double down on the pressure. Other times they get nervous because they know you're getting wise to their game. In one memorable case, a client from Evansville was told his offer would expire in 48 hours. We called the bluff, and surprise, the offer was still there a few weeks later, and the offer was even a little higher. You don't have to sign anything right away. If you feel pressured, say you need time to think, talk to your family, or maybe consult a lawyer. If they give you grief, remember, their urgency is all about their bottom line, not your best interest. The fifth and final question might be the most powerful. Say, should I talk to a lawyer before I decide? Insurance adjusters do not want you to ask this. Why? Because they know that once you involve an experienced Indiana personal injury attorney, the playing field evens out. Studies show that people who hire lawyers after an injury get significantly higher settlements, even after paying the legal fees. Adjusters would much rather deal with someone who's in pain, confused, and flying solo. When you're asked if you should talk to a lawyer, you put the adjuster on the spot. If they say no, that is a red flag because the answer should always be yes, especially if you feel uncertain, if you feel pressured, or if your injuries are serious. If they say it's up to you, take them at their word and make the call. I've seen cases across Indiana where adjusters try to discourage people from getting legal help. I even had a client from Michigan City whose adjuster said, "Lawyers just slow things down and take your money." That's not true. A good attorney will tell you if your case is worth fighting for and help you avoid mistakes that could cost you thousands of dollars. Bottom line, if you feel even a little unsure about the offer, pick up the phone and get a free consultation. Most Indiana personal injury attorneys, including my firm, don't charge anything upfront. We only get paid if you win. Your future isn't something to gamble with. There you have it. 5 questions insurance adjusters don't want you to ask in Indiana. If you remember nothing else, remember this. You have the right to clear answers, a fair process, and the time to make smart choices about your recovery. If you found this helpful, you cannot miss our next video. 4 steps you must take to win your wrongful death claim. In that video, I'll cover the exact steps families need to take after a devastating loss, including a few most lawyers don't talk about, but can make or break your case. This is critical information if you want to protect your rights and your peace of mind. Click through and watch. Trust me, you'll be glad you did. See you over there.